Be ready. Start. Madam, in respect of this bill, along with the amendments which have been brought from the side of the government after discussion yesterday, broadly we welcome the bill itself, but this should have been discussed amongst the chief ministers of the various states. They are the implementing agency. It is being done very expeditiously, but much discussion is needed in this bill. Every citizen, including a woman, is having the right to live with the dignity and honor which is guaranteed in Article 21 of the Constitution. Sexual harassment, like even teasing of women, amounts to violation of rights guaranteed under Articles 14 and 15 of the Constitution of India. For meaningful right within the ambit of Article 21 of the Constitution, every woman is entitled to enjoy economic, social, cultural, and political rights without discrimination. The primary concern, both at international and at the national level, are about devastating increase in rape cases and cases relating to crime against women. India is no exception to that. Sexual violence is not only an unlawful invasion of the right of privacy and sanctity of the woman, but a serious blow to the honor. It leaves a traumatic and humiliating impression for her conscience, offending his self-esteem and dignity. Rape is not only a crime against the woman, it is a crime against the entire society itself. It leaves a scar on the most cherished possession of woman, that is, her dignity, honor, reputation, and not the least her chastity. It destroys entire psychology of a woman and pushes her into deep emotional crisis. It is a crime against basic human rights and also violates the victim's cherished rights in that context. Today is very important day because this bill has come. Para, I have said I have not denied it, but it is not a taxation measure in the ordinary sense of the term. If we had not done it, we could not have taken it up. If we had waited for bringing in a measure in the House at that time, what were we to do for the interim period? Could we have allowed it to be passed on to the consumers for 2 months and then levy it again? It would have been real taxation in the middle of the year, but that is not so in this particular case. More so because, as I have said earlier in my speech, this ad hoc reduction, the condition of the agreement is that if after examination by the cost accountants, if it is found that what we have taken is not justified by courts, we will have to give them a rebate. If we find at the end their costs are still less, we will be entitled to a greater reduction. It would not have caused any harm, but if we had to return anything, then it would have been very difficult to return it. If it had been passed on the consumers, because in that case we would have to give a rebate. The rebate would have been given by getting something more from future consumers and that present consumers would have got all the advantages, and I do not think that it would have been a fair proposition. It is therefore that after a great deal of deliberation we decided to go this. The question was asked as to why we took so much time from the 20th of May to 30th of June to promulgate that ordinance. That shows that we did not do lightly stop